Mute yourself, Jeff.
Yes, you are.
The Supreme Court is now in session. The Honorable F. Philip Carbolito, Chief Justice, presiding.
Good morning, gentlemen, and will the clerk please call the case?
This is Supreme Court case number CVA20-021. Richard E. Moylan, plaintiff, counterclaim, defendant, appellant, versus Axe Murderer Tours Guam, Inc., Paseo View Properties, Inc., EC Development, LLP, John Doe Companies 1 to 5, and John Doe's A to M, defendants, counterclaimants, appellees. Axe Murderer Tours Guam, Inc., Paseo View Properties, Inc., EC Development, LLP, third-party plaintiffs, appellees, versus Douglas Moylan, third-party defendant, appellant. Appearing for the appellants, Richard E. Moylan and Douglas B. Moylan, are attorneys Curtis C. Vandeveld and Douglas B. Moylan. Appearing for the appellee, Axe Murderer Tours, is attorney Jeffrey A. Cook. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Robert J. Torres, and Associate Justice Catherine A. Merriman. Attorneys Moylan and Vandeveld reserve 5 minutes.
All right, Attorney Douglas Moylan, you will be doing the opening arguments, and you have 20 minutes, as I understand that Mr. Attorney Vanderbilt will take up 5 minutes of your first 25 minutes. Attorney Douglas, Moylan, you may proceed.
Chief Justice, may it please the court. Your Honors, we believe that the lower court correctly decided this matter on its first 2 decisions, and on the third decision, which was the second motion for reconsideration by AMT, they cited the 2020 decision by this court, as this high court, as it relates to the Cho decision. Subsequently, the court, on addressing the CPGA, has issued the Joe and Flo decision. We believe, Your Honors, that the Joe and Flo decision is highly probative towards this next evolution on Guam's interpretation of our CPGA, which is oftentimes referred to as the anti-SLAPP statute. Joe and Flo had referenced not only Duracraft, which is the Massachusetts line of authorities, but also California in the Park decision. Interestingly, on the California Supreme Court's Park decision, they also had the Barral decision, which was issued in 2016. That case, Your Honors, referenced the Cho versus Chang within the Barral decision, and that was a 2013 appellate court decision, which is almost procedurally exactly on point to what's going on here. Because this is a counterclaim, it's kind of twisted what the normal anti-SLAPP cases review, where the plaintiff sues the defendant and the defendant brings the anti-SLAPP motion. But in this case, Richard was the plaintiff in the case and a counterclaim was filed. Your Honors, unlike the other facts that this high court has reviewed on the Enriquez case, the Guam Greyhound case, as well as the Cho and Joe and Flo cases, we have a signal by the plaintiff, the counterclaim plaintiffs in this case, via 2 letters that they issued in 2017, which is part of the record, excerpts of record 318 and 322, by an attorney that represented by AMT previously, and is not the counsel appearing today. That letter specifically signaled that they were going to sue Richard and his counsels if they persisted in reporting what appeared to be hazardous conditions on property surrounding this lot 1051. I would also say to Your Honors that on the properties in question, there's many fractional lots, and there were 2 maps that were part of the excerpts of record that would assist the high court in understanding what was going on here. And those were excerpts of records 43 and 123. In the Cho versus Chang case, which the California Supreme Court adopted, they specifically envisioned plaintiffs attempting to use pleadings to bootstrap in allegations that were not part of the protected activities. Joe and Flo, by this high court, specifically made the statement that the artful pleadings cannot, well, I'm sorry. Joe and Flo specifically stated that the basis for liability, the protected activity cannot be the basis for liability, but in that case, it was evidence of liability. We contend, Your Honors, that in this case, which deals with the harassment and the TIBR, the tortious interference with business relationship, they put protected activity, which was reporting to the the 5 government departments, in with the unprotected activity, which they alleged as certain forms of harassment and TIBR. Your Honors, the Massachusetts Authority in the Jace Boston case and the Blanchard case talk about how plaintiffs attempt to mix, and they call it the mixed claims line of cases, the protected activity with unprotected activity, and that how the courts should separate them and glean out the protected activity and the unprotected activity. We're not saying that this case should wholly be dismissed, although it's new ground for Guam. We're saying that if the court looks at for instance, the harassment claim, there's clearly, and they specifically spelled it out, unlike the Joe and Flo case, where trespass was in the background that a complaint was made to GPD. Here, the AMT specifically spelled out what they threatened to do months before in their letter of February 2017, that they were going to sue for the harassment by reporting to the Guam Fire Department and the EPA, as well as the other agencies, which they considered harassment.
Let me ask this question, Mr. Moylan. When I looked at the complaint, obviously there are a number of allegations that are contained in the counterclaim, and Mr. Cook asserts that the allegations concerning the reporting to the government agencies, I think he acknowledges that could be protected activity, that those actions are alleged not as a basis for liability by the complaint, but just as evidence of the overall harassment and tortious interference with contractual basis. In other words, he's saying that he's not complaining or seeking a basis in liability based on your petitioning, but based on the other conduct that is alleged. And this is just additional factors to show as evidence of this harassment and tortious interference.
According to the way that the counterclaim was drafted, they specifically put together as a 5th cause of action and I believe is the 4th cause of action, many different allegations that are going towards what they call harassment. Each one of those at the court, and I know the court is a notice pleading jurisdiction, but in these cases that we've cited in Massachusetts and California, they say that you look to the allegations, and if they can be separated out, which in this case it clearly can, because they're alleging a non-protected activity, like for instance, I went up to somebody and put a camera in their face as a form of harassment. Well, they also allege that in their paragraph specifically that a complaint was made by Richard and myself to the Guam Fire Department. That is unrelated to putting the camera in the face and at a different point in time. Those could actually be segregated out in a count. Count 1, attorney goes up and puts a camera in somebody's face, and that's harassment. Count 2, attorney sends a letter to the fire department that says that there's hazardous activity of gases being compressed and stored in a commercial zone next to a beach, sort of thing. So justices, that's why I mentioned that Massachusetts and even California talk about a category of cases called mixed claims cases. They specifically identify it as that. And they've looked at the allegations, and in this case, I would respectfully submit that the allegation of turning in a complaint to the government law enforcement official, who by the way is a peace officer under our code, which specifically can charge crimes, is a form of basis for the allegation. It is not evidence, but they're suing and asking a jury to award punishment and damages according to the act of turning them into the fire department and EPA, as opposed to putting the camera in somebody's face, which is a separate count. And in the cases that we presented, they try to protect the interest of the movement for the anti-SLAPP, which is Richard and myself. The plaintiff in the case, which is AMT, as well as the important government interests. And of course, we know that the personal interest is the freedom of speech and the freedom of the right of petition for the movements. In this case, the government has a very strong interest in ensuring that, unlike the Enriquez case, which was a private cause of action or private reporting, this case involves arguably a higher degree of protection because they are compressing gases for the scuba tanks, which contain oxygen and nitrogen, and storing them in a container on lot 1056 and 1057. And those were the photos that were supplied with the emails and provided to the lower court through the affidavits. And those excerpts of record included 387 to 467. If those tanks explode, you have tourists and children on the beach, and you have the commercial businesses, including Richard, who's on lot 1051, which is adjacent to lots 1056 and 1057, which contain the compression of the storage tanks and the storage of them. In addition, there were no business licenses that they produced that showed that there was a license for that, which had they done so.
If the claim that he had brought for harassment and tortious interference was based solely on or substantially on the petitioning activity, the complaints that had been filed, it would appear to me that those claims would have been immunized by the CPGA. But when when you look at the complaint, the counterclaim in this case, it's not apparent to me, based on the counterclaim, that even though he does address the filing of that within the counterclaim, that it's not apparent to me that he's trying to assert a basis of liability by reason of you filing those complaints, or Richard filing those complaints with the relevant authorities.
Your Honors, if the court reviews the first letter of February 3, 2017, which is excerpt of record 318, as well as the second letter of 2/13/17, excerpt of record 322, they specifically equate the reporting to government officials as harassment of AMT. In the excerpt of record 637, which is their fourth cause of action, they indicate that within 2 days of Axe Murder's submissions of business license, Axe Murder was inspected by the Guam Fire Department, the Guam Environmental Protection Agency for reported illegal business activity by Richard Moylan through his agent, Douglas Moylan. Unlike the Joe and Flo case, where you had to bring in a lot of extrinsic evidence to try to establish it, they have specifically put it in their complaint as to the harassment. And then on the TIBR, excerpt of record 638, again, they're referencing the submission of the business license unrelated to lot 1051 Axe Murder was inspected by the Guam Fire Department and the Guam Environmental Protection Agency.
So Mr. Moylan, if I may just, so what you're in effect, if you're asserting that the nature of the complaint, the counterclaim and third-party complaint here, that a basis for the causes of action are these petitioning activity, that's your assertion. Of course, there's a difference in reference to what Mr. Cook has alleged in his briefs, and that the assertions attributable to what we have described here as petitioning activity, reporting to government agencies, forms a basis of liability, then as Justice Torres points out, that is immunized. But if we go back to Cho versus Alupang Beach, because I think that's the pivotal case that guides Joe and Flo's, the facts are a little different. But in Cho versus Alupang Beach, we said that where the complaint is not solely based on petitioning activity, in that particular case, they had a settlement agreement in which the plaintiff was asserting there was a breach of contract. And in addition, there were allegations that reference going to the land use planning agency and making these complaints that were seemingly in breach. So in that case, we said that since it was not solely based on petition activity following the Duracraft and the Sanhome, Illinois case, that was not in the CPGA did not provide protection for those claims. So are you asking us to overrule Cho, a case that was just issued last year by the Supreme Court?
Thank you for the question. Not at all. The next evolution in the court referenced the High Court. This court referenced the Duracraft case, which was a 1998 case. As recently as, and actually a lot of these cases came out in 2016, 2017, when the other Supreme Courts were dealing with a category of cases called mixed claims cases. And that's why in our brief, we take great effort to point out that unlike the Cho case, which had the parties had a settlement agreement, that as part of the settlement agreement, I guess the Land Use Commission was envisioned as related to it. This case had nothing to do with either the lawsuit that Richard brought, which was lot 1051 in a contract issue, and the issues between the parties. This was an unrelated matter. While on the property and preparing for trial and investigating, things were noticed and those things were reported. So unlike in the Cho case, there is a nexus between the parties and then an agreement that they entered into. And that's why I say when the Supreme Court entertained the Joe and Flo decision opinion, it actually was the next evolution of determining people that are talking to the government while they're in litigation or in a
The
dispute.
Joe and Flo's more had to do with the motivation for the suit. We didn't feel that that was relevant
Correct.
in reference to the actual allegations in the complaint and what was asserted and the conduct that was prohibited.
Yes.
And that formed the basis of the liability. But you know, the Blanchard case, that all came out prior to the Cho case. And so, you know, while that may not have been discussed, I'm just very troubled that the principles laid out in the Cho case are going to be so soon after, you know, 1 year on the books that we're now overruling. I just don't think that that the principle of stare decisis and the basis for, you know, the issuance of Cho versus Lupang Beach and Joe and Flo's can be so summarily overruled.
I respectfully disagree, Your Honor, that you're actually overruling it, because the Cho case did not address the mixed claims category of cases. And that's why I say when this court is referencing the Massachusetts and the California line of cases within the Cho decision and the Joe and Flo's, it goes hand in hand with exactly what's going on this case. But in order to draw the contrast, after reading the AMT's brief, this is the contrast that really shows the problem here, is that you could have a crime victim make a report to law enforcement for whatever, you know, personal crime, a crime of violence and so forth. And you have the defendant filing a lawsuit for harassment. They include the idea that
clearly in those facts of those case, Mr. Moylan, you know, the 17104 anti-SLAPP statute immunity that is that in those facts that you point out would apply. I mean, the CPGA would not allow that type of complaint.
Actually, Your Honors, no, it wouldn't, because this is the exact case, and that's why I mentioned earlier, the Guam Fire Department is a peace officer in a Guam law, HGCA 5.55. Also, the act that was complained of constitutes reckless conduct under 9 GCA 19.40A, which is a crime, a misdemeanor. Also, failing to have a business license for lot 1056 and 1057, where they're doing the compression, is also a misdemeanor under 11 GCA 70119. Revenue tax officials are also considered peace officers under 8 GCA 5.55. In the affidavit, we specifically identified the persons who were reported to. These constitute potential crimes because when those tanks explode, if they explode because of the oxygen, they become shrapnel. And that could be part of a reckless conduct. And especially when there was no business license where land management would have come in and says, you got to be like Island Equipment. in an industrial zone separated from all other businesses because of the danger of explosion. And that's just one aspect of this. There are storage of chemicals, generators, and so forth. But if this case stands for the proposition that a plaintiff can put protected activity with unprotected activity in a complaint, and the defendant cannot receive protection, not only will the jury be asked for damages for having gone to the law enforcement officials, but crime victims are going to be affected because, again, you can take a crime of reporting and then throw in other things. Oh, this person was throwing things over my gate and creating a nuisance to my house. At the same time that a police complaint had been made that this person came in and assaulted the individual. So that's why the separate counts test that Blanchard's talked about, but Jace Boston specifically talked about, you must separate out the protected activity from the unprotected. Bernal, mixed claims case, that was a abusive process case. They said, well, there's some that are unprotected, but they're clearly protected activities. That's exactly what's going on this case. And the Supreme Court of California in the Bernal case cited the Cho versus Chang case. Interestingly, we have two Chos here, but the Cho versus Chang case 2013 was procedurally exactly the same as what was occurred here, procedurally. And then the substance of it is the same, although theirs was a bit different in terms of defamation, intentional infliction of emotional distress being the counterclaim. Your Honors, I believe the implications are very serious as to in this category, and that's why I say none of the arguments and the cases made prior to this address this. Enriquez too was exactly the type of danger, and even more so because we're going directly to law enforcement for protection of the public's health, safety, and welfare, but especially the safety aspect. And that's why the court below specifically talked about, she found merit to the allegations that were the reporting that was being made. And that was cited in Excerpt of Record 600 as part of the decision. Your Honors, if I may defer to Attorney Vanderbilt for his time.
Thank you.
Thank you.
Good morning, if it pleases the court, Your Honors. I believe that this case can be read in harmony with your Cho decision. Your Cho decision did not address when allegations within a claim contain information that is a basis for the liability based on protected activity that the individual engages in. And where there is a reference to counts in the cases cited by Mr. Moylan, there are no counts relative to each of the causes of action in the complaint. The second cause of action is the cause of action for harassment. It has several paragraphs, which some could independently stand alone as a basis for harassment. So it's an artful pleading intention to take some things that could be one separate count and mix it all together so that they can avoid what would otherwise be the effect of the CPGA, which is in paragraph 31, upon information and belief, within 2 days of axe murderer's submission of a business license unrelated to lot 1051, axe murderers was inspected by both the Guam Fire Department and the Guam Environmental Protection Agency for reported illegal business activity by third-party defendant Douglas Moylan. I would point to the language of 7 GCA section 17102A, even in paragraph 9. And I understand that the court in Cho referenced paragraph 7 for the fact that the only lawsuits that were intended to be avoided were groundless lawsuits. But in paragraph 9, it says, while some citizens' communications to government inevitably will be incorrect, unsound, self-interested, or not in good faith, it is essential in our democracy that these constitutional rights of citizens to participate fully in the process of government be uniformly, consistently, and comprehensively protected and encouraged. And so this argument about asking the court to look at the various paragraphs to see whether or not they could be parsed off under the same cause of action. And if so, if they were parsed off and a separate cause of action, would that separate cause of action offend the CPGA? And what Mr. Cook wants to do is he wants to take the decision from Cho and use it as a sword against the concept, the very basic principles of the CPGA, which is to protect communication. As Mr. Moylan argued, this is not only about trying to communicate with boards, which is in some of the cases that were decided. This is really goes to the core of citizens being able to report what they perceive as criminal activity. So if I perceive something as criminal activity, and I'm, as paragraph 9 of 17-102A says, I am
But Mr.
incorrect,
Vanderbilt,
unsound.
isn't the anti-SLAPP statute to provide a mechanism, a special motion essentially to deal with groundless lawsuits that will prevent, that people bring in an effort to, they basically are an abuse of the judicial process intended to intimidate people, and it was not intended to address the situation where there might be bona fide claims that might exist as a result of the relationship between the parties. And so to be entitled to this special expedited dismissal of a lawsuit is what the anti-SLAPP was intended to do. Basically looking at balancing the rights, not wanting to prevent someone from filing a lawsuit and getting a right to trial by jury, but also wanting to balance that with the right to speak out, recognizing that many of these lawsuits that had been filed were not aimed at bona fide claims that they had, but just to essentially try to influence the threat or to threaten people from going forward on that basis. And so the idea of whether a certain act might be immunized is still protected. Even in this case, it would seem, it doesn't seem to me that there would be a basis for liability solely on the petitioning activity, but as to whether or not an expedited dismissal of the proceeding should result from the motion by the moving party on the anti-SLAPP basis. I mean, I think Cho makes clear if there's a substantial basis for the claims other than the petitioning activity, it's not entitled to the summary dismissal.
And I think that what we're saying is that it can be parsed off. I think that Cho can still stand, and that those portions of the lawsuit which do not offend the CPGA can still survive.
So are you suggesting that the tortious interference with business relations and the harassment claims would both be dismissed, or you're saying that there are elements of those claims that would survive? Because when I read the counterclaim, it seems like these are all the allegations are contained in there, and that I agree with. But as Mr. Cook says, we put those allegations in not as a basis for liability. The liability is based on not on the petitioning activities, but the liability is based on hitting one of the employees and taking all these pictures or coming right up to their face. Those are the allegations that they say constitute the harassment and tortious interference. And he says the allegations of petitioning that are contained in there just show that this is evidence of the liability, not the basis for the liability.
I understand. What I'm saying is that I think that you can harmonize all of the decisions and still end up with what is the intent of the statute, which is to protect people from being sued for their exercise of constitutional rights. I would point out that at pages 650 to 651, the last two sentences of page 650 and the first five sentences of page 651, Judge Iriarte still maintained that the basis of the complaints that are referenced in paragraph 31 of the counterclaim on harassment and in the fourth cause of action for tortious interference with business relations at paragraph 40, each of those refers to what is clearly protected activity. That activity can be severed off and would serve, if it were severed off, it would state a claim that clearly would be contrary to the protections intended to be afforded under the CPGA. And to allow a lawsuit to go forward containing both claims that have that are appropriate and those that are clearly not appropriate goes against what is the intent of the statute, which is to make sure that when someone is being sued for their exercise of protected activity, that they do not have to go through the litigation costs relative to that. And so you can harmonize this. You can take and say, okay, trial courts should maintain those causes of action and portions of causes of action which do not offend the CPGA, but where they have alleged something which is absolutely a violation of the CPGA, it should be struck. There's nothing that would be inconsistent with your intent to protect the citizenry of Guam from frivolous lawsuits that are designed to impugn people or negatively impact them financially because of the fact that they are seeking protected activity. And when it is something which is as crucial to good operating society, which is for people to be able to report violations of law, you will chill people from making reports of violations of law, because then they have to try to decide if you're going to allow it to be lumped in with some other causes of action. And so through that artful pleading, those same circumstances that would violate the CPGA can now move forward. Then what will happen is that people have to sit and go, well, let's see, is my report of this criminal violation one which might ultimately be determined to be incorrect, not well maintained. Maybe I misunderstand the law.
Mr. Vanderbilt, when
Yes, Your
you
Honor.
say that these are exceptions, are you arguing that the exception should only be for reports of criminal activity? You and Mr. Moylan both seem to suggest that. Or is it any petitioning activity to the government?
I believe it should be any petitioning activity. I'm referring to the criminal violation reporting as something which is a heightened, in my opinion, a heightened level of what the CPGA is intended to protect. So this goes to circumstances as an example of a more heightened nature. But I think all reporting, I mean, that really is clear in 17102 that all.
So in Cho, the court ruled that there were two allegations there, one of the violation of the agreement and also some activity towards the Land Use Commission and petitioning for certain things there. So isn't it already decided in Cho that if there's a combination of both petitioning activity and another activity, then the case goes forward? So wouldn't we be impliedly overruling Cho?
No, I don't think you'd be overruling Cho. I think you would be narrowing what the impact of Cho is. And that happens from case to case based on the various circumstances that are presented to the court. One ruling that you make is based upon what the facts are that are presented to the court in that particular case. And in this particular case, they're substantially different. And I think that, so I believe that the decision in Cho, while it might be impacted, it isn't being overruled. It's simply being narrowed based on the circumstances. And in this particular case, Judge Iriarte found that there was a basis for having made the reports to the government agency that made these complaints appropriate. And
But even if the lawsuit proceeds in the manner that it does, can't you still defend the acts of petitioning from a basis of liability relying on 17-104? It's just that the lawsuit is not now dismissed. And so you would still be able to defend the petitioning acts as being immune from liability if they wanted to assert as a basis for liability the filing of the complaints with the relevant authorities. There's nothing that this doesn't mean that you're banned from raising a defense of immunity from liability from that. All this is doing is essentially saying there's a basis for the claims that have been brought other than the petitioning activity. And so that these complaints are going to survive the special motion to dismiss. And in fact, I don't think there's anything that would say to prevent you, if you wanted to, based on the evidence that comes, to say there was an abuse of process. If he's asserting, and he seems to suggest he's not, that solely the act of petitioning is forming the basis for the liability for the harassment and tortious interference claims.
So Mr.
Motion to
Vanderbilt,
dismiss.
just a second. I'm going to give you a minute to wind up. We have extended you 15 minutes of argument time. So I'm going to give you a minute, and so we can have Mr. Cook present his arguments, and you can then raise your final comments in rebuttal. Please abide by that.
Understood, Your Honor. So the response is this. There is the motion to dismiss is like a motion for summary judgment. And so in reversing the decision of the trial court below, when she found that the circumstances were that there was appropriate reporting to the government of the citizen complaints, particularly relative to the criminal reporting in this case, denying that protection in that context denies that summary judgment. So to say that somehow we can get some other form of summary judgment when that square issue is what is in the decision and order would be, it really doesn't work appropriately. The court could have said, okay, I'm not going to dismiss the action but I'm going to strike those offending portions. But that wasn't what the decision said. The decision
What was the
left it
motion
all
that
to
you
go
brought?
forward.
What was the motion that you brought below?
The motion was the motion to dismiss based on the CPGA.
So it was not a motion for summary judgment or judgment on the pleadings.
But it
There
is
was a motion
treated
to
as such
dismiss.
for the purpose under the statute.
All right. Thank you, Mr. Vanderbilt.
Thank you, Your Honor.
And the rebuttal between you and Attorney Moylan, you can raise your additional points. Attorney Cook, you now have the floor.
Thank you, Your Honor. If it pleases the court. A lot of the questions the court has asked is kind of where I was going to argue. The first thing I'd like to point out once again, and I believe Mr. Vanderbilt talks about 17102A9, but I think the more important portion of that section is 17102B2, which is the section that talks about equitable balance. And that's the section that this court talked about in its previous cases, particularly Cho, and it cited to Sandholm and Park from California and various cases. And the reason the equitable balance is important is the the Massachusetts statute and the California statute, neither one of those have that language. So for instance, in the Massachusetts cases, if we go through those cases, they have the Duracraft, which this court properly cited. There's the Blanchard case. And now it turns out actually there's a Blanchard 2 case, because in Blanchard 1, the court set it back down after it made some narrowing of the Duracraft decision. It sent it back down to the trial court to determine whether or not it was a slap under the narrowed provisions. And in Blanchard 2, the Supreme came back up and the Supreme Court said, no, the court was properly, the trial court properly found that there were colorable causes of action and they were not done to try to somehow punish the defendants.
Well, what
And
about
once
in
again-
this case where they point to the letters that prior counsel had sent threatening, based on the petitioning activity, that they were going to bring a cause of action, and then included some of those allegations in the cross claim?
Well, first of all, Your Honor, my reading of those letters is that it was not a threat. What was being brought up was the case was already ongoing. There were discovery issues ongoing, and prior counsel was pointing out to plaintiff's counsel that they felt that what they were doing was violating normal discovery processes. They did not threaten that they were going to file any sort of suit or counterclaim. They said that they were going to raise these issues appropriately. It turned out that we felt when we filed the counterclaim that those were arguably matters, as we pointed out, not to make a case for the cause of action, but they were evidence of what was all the other things that were pointed out in those letters, which were also pointed out in our counterclaim and our cross claim, all of the activities by both Mr. Moylan and his father. So it was our position that those letters don't really go as far as Mr. Moylan has argued they do. And I leave it obviously to the court to interpret the letters as it sees proper. And once again, going back to this court's decision and Cho, and as I believe Your Honor and also Chief Justice brought up, I mean, the Cho case talks about equitable balances and it talks about solely. Is the claim solely based on protected activity? And once again, it cites Duracraft, Sandholm, Blanchard, and all of those cases basically hold no. If there's other bases for the claim other than the protected activity, the case should move forward. As Your Honor pointed out, and I'm sorry, in one of the questions, the case would still go forward, and it's very possible that certain allegations are immune, and that could be raised. But then again, there is this aside that a jury might say, well, no, that the reason the person did that wasn't, as the CPGA talks about, to get government action. It was to basically be harassing.
Mr. Cook, Mr. Moylan.
I'm sorry.
Mr. Moylan and Mr. Vanderbilt are not advocating that the causes of actions be dismissed. They're advocating that we maybe distinguish Cho and the certain allegations that assert protected activity be stricken. And of course, if that's the case and that they prevail in that regard, there may be consequences as a result of that, as you are maybe fully aware. You are fully aware whether or not those consequences come to pass are issues that may have to be decided. And so my understanding is they're not asserting that the claims itself be dismissed, but the allegations that assert petitioning activity be stricken, as they pointed out, Massachusetts, in terms of the Blanchard case, has digress or taking Duracraft on a certain direction. And so, but in my mind, would that in effect just be overruling Cho? And in reference to, as has been pointed out, the fact, as Justice Merriman pointed out, the complaint in Cho had the cause of action stemming from the breach of the settlement agreement. But part of the allegations is that the breach was, part of it was going to the Land Use Commission and filing an objection, which the settlement agreement very much stated was not to be permitted. And in that particular case, since we said that the claim was not solely based on going to the Land Use Commission, but there was a separate basis for it, and that is the breach of the settlement agreement, we decided to follow, the Supreme Court decided to follow the Massachusetts cases, Duracraft, and the Illinois case of Sandholm. So is there a distinction in this case?
I don't believe so, Your Honor. That was my next point, was that there isn't, and this would be overruling Cho. That in fact, Cho was a arguably mixed cause of action case. I mean, I guess the same argument could have been made in Cho, that they could have been separated in two causes of action and one goes forward and one doesn't. But when you adopt the legal principle that it's solely based on protective activity, that's pretty clear. And when you adopt the issue of, is there substantial basis other than the protective activity, that's also very clear. And we feel very strongly in our counterclaims that that's exactly what we were alleging. We're alleging a number of facts that which are taken as true in a motion to dismiss, that occurred that were trespass, harassing, and interference and nuisance.
But what Mr. Moylan has pointed out is that then rewards artful pleading, where councils, enterprising counsel, can seek to penalize protected activity by lumping it all in a cause of action that also includes unprotected activity. Should we pause and see if that's the public policy that we want to continue to advocate in our jurisdiction?
No, Your Honor. The Cho decision is a good decision. It's a good melding of our CPGA. And once again, our CPGA is taken after the Model Act. These other states didn't. The closest one to follow the Model Act that's being discussed in all of our cases is Illinois and the Sandholm case. And the Sandholm case was mixed. There were allegations of protected activity and not protected activity, and the court went forward. Even now in the Massachusetts case, as I said, the Blanchard 2 case has sort of said this isn't a slap anymore. They've taken the mix and said, no, the court made the findings we required in our change in Duracraft. So no, the current law and the current interpretation of the law by Your Honors, I believe, is very correct. And I would also like to point out that when Mr. Vanderbilt points to the decision of Judge Ariarty below the trial court, that initial decision she made where she kind of parceled in and out protected activity, that was based on this court's prior decisions before it made Cho and before it made Joe and Flo, particularly Cho. And so when those were brought to her attention, she went back and said, okay, that changes things, because Your Honors read the statutes, read the other cases. And I think, once again, that equitable balance, I believe, is a very important part of what Your Honors relied on in Cho. And I believe that's a very important part of the model the model act, because our act includes sanctions, not just attorney's fees and costs, but includes sanctions, which is in the model act. California doesn't have sanctions. Illinois doesn't even have sanctions. And Massachusetts don't have language for sanctions. They only have attorney's fees and costs. And the reason I believe that the Model Act had sanctions, if you look at the book that created the SLAPP Act, was because of a classic SLAPP. And for Guam, I would point to Greyhound. Greyhound is the classic SLAPP. A very wealthy individual suing a relatively modestly income woman over political activity. That's the classic SLAPP. And that's where you get not only attorney's fees and costs, but you get to the next step, which is sanctions. And I think the fact that the Guam legislature adopted all of that means, and I believe that's what supports the court's decision, you need to look at this equitably and not strike out, divide it up and say, okay, this is a cause of action and this is not. We did not make a separate cause of action for raising issues of government activity, because we didn't see those as separate causes. We just saw those as evidence of, to support the harassment, to support the interference with the business.
Let me ask this. It was pointed out, there was some discussion, I think I read in your brief, that the petitioning activity here may not have been intended to procure government action, sort of asserting that maybe potentially it was a sham, which seems to be contrary to what the judge may have alleged. And obviously you did not, Mr. Moylan says you did not appeal the ruling by the judge that it was not a sham, or rejecting this sham exception argument. Obviously that was done, or presumably done, before the judge reversed herself and denied the motion to dismiss, and originally granted the motion to dismiss. But so what is your response to that?
Why we didn't appeal the sham?
Or even why?
Well, first of all, I believe it is evidence to support a sham, but I just procedurally, the way things were going, we were asking for, as there was that long hiatus in the case where there was an attempt to see if a settlement could be reached. And then we filed our motions for reconsideration. So we never really got to filing a notice of appeal. And then the court granted our motion for reconsideration based on Your Honor's decision in Cho and Joe and Flo. So,
but obviously, I
can't honestly say whether we would have appealed that or not. But I mean, we did feel that it was evidence of sham.
But obviously, if this was, there's nothing to prevent the trial court from examining whether the act in furtherance of the right to petition is immune from liability, right? I mean, are you asserting that you did not bring a cause of action based on the petitioning activity?
Correct. We did not. That wasn't our intent. We brought a cause of action for trespass, for interference. We laid out facts. Part of the evidence for that we felt was these reports. And as pointed out in the affidavit from Ms. Stackus, which was, it's one of our excerpts, based on, at least on her conversations with these government people, we felt that if we had ever gotten into discovery, the discovery would have shown that it was a sham, but we didn't go down that road. That would now be something, and I would agree, it's very possible that the court or a jury would say, no, those activities are immune and those should not be the basis for any sort of liability, and that would be how the case proceeds. But at this point, just to parcel out the case, and that's the other problem. Right now, where the case was at before the court reconsidered based on Your Honor's decision, was we were going to go forward on attorney's fees and sanctions. Well, we were going to go forward on attorney's fees and sanctions, but we still haven't even gone forward on the major case. And conceivably, if my client prevailed on its case, then the question would be, did the plaintiffs really prevail on the slap if we were to make the case? It just creates a real mess having this broken up, excuse me. And it's our position that, once again, your honors have been very clear in show, and we feel that that's clearly the right decision. I also want to emphasize that I believe that even the California cases, because if you look at Park, they go, you cited that case, and I understand Burrell. Burrell's a very there were special facts in Burrell, but I once again go back to the fact of the difference in our underlying statutes. And that's why I would ask this court to continue to create the law as it deems appropriate based on its reading of the Model Act, because that Model Act is very different. And I've tried to look at almost every state's SLAPP statute. There's about 26 states, I believe, that have adopted some form of a SLAPP. And basically, Guam's the only one that took the Model Act and just said, this is the law. And I think that's important, because I think that goes very much toward your honor's decision in Cho in the whole idea of solely, and the whole idea of substantial, and the whole idea of equitable. Those three principles are set forth in Cho, and they clearly deal with the mixed cause of action that Mr. Moylan and Mr. Vandevelde are arguing. I think the case goes forward, and those matters can be gleaned out through discovery and trial.
While
I might have a moment.
Mr. Cook, while you are thinking about your next point, you've said you've surveyed the 27 some jurisdictions, and I'm sure I'll have the opportunity to partly do the same. But does the Illinois anti-SLAPP statute have the sanctions provision?
No, it does not, Your Honor. It has attorney's fees and costs. The only state I could find that had actually a sanction provision right in its statute was Texas. Texas, it's written differently, but it kind of goes along with the model code. Most of the states just have attorney's fees and costs. They do provide, obviously, that you can bring a case for abuse of process, malicious prosecution. You can bring a case afterwards, but they don't have right in their statutes this sanction language that was in the Model Act.
Thank you.
And I actually, once again, I would like to, I know I mentioned it, but I'd like to emphasize, because neither Mr. Moylan, Mr. Campbell, or I cited Blanchard 2. Blanchard 2 is found at 130 Northeast 3rd, 1242, a 2019 decision. And what Blanchard 2 was, as I stated before, Blanchard 1 narrowed or refined, I guess would be a better word, a Duracraft. And as the court pointed out in Massachusetts, the reason they were doing what they were doing was because the way the statute read, it was being interpreted as providing absolute immunity. So the Massachusetts court was trying to work it to make it more, quote, equitable. And so in Blanchard 1, they set forth these new rules, sent it back down to the trial court, and the new rules talked about whether or not it's a colorable claim and whether it was a retaliatory claim. And in Blanchard 2, the defendants brought it back up because they had lost again in the trial court, and the Blanchard 2 decision was the trial court was correct in finding it was colorable and it was non-retaliatory, and therefore it was not a SLAPP. And once again, that was a mixed cause of action case, has been cited. And that was the case of the nurses against the hospital. So I just point that out because it shows that even the Massachusetts court has found after a proper analysis that something wasn't a slap. Unless, if I might, just very quickly, I apologize. That's right. Your Honors, unless you have any other questions, I think I've covered the points I wanted to cover and responded to the plaintiffs.
Justice Merriman,
Thank you.
do you have any other questions for Mr. Cook? Okay. If I can just jump in here. Thank you, Attorney Cook. Mr. Moylan, I understand that you are going to do the rebuttal. If I can just jump in here and ask a question as a result of Mr. Cook's presentation. He points out that the Guam CPGA has a sanctions provision that is taken from the Model Act, unlike the other jurisdictions, which of course, the court will do its own survey, assuming that is the case. Is that a reason for us to distinguish whether or not we now take a divergent path from Blanchard, from Duracraft in following or not following Blanchard and Baral, because if their Guam's statute is unique and we have this sanction provision and claims are stricken, we have protected, unprotected activity. We decide to follow Blanchard and Baral, that then what we have is trial courts striking protected activity from the causes of action, and then that triggering whether or not under the Guam's anti-SLAPP statute, the movement is then entitled to the remedies provided in the Guam statute, which in the other jurisdictions include attorney's fees costs. That's not before us, but I'm just wanting to know if this is a basis for us distinguishing and not necessarily following these other jurisdictions that have set different policy paths from the original Duracraft decision. And does that form a basis for us to distinguish the Guam statute from the Massachusetts and California statutes?
I don't believe so, Your Honors. And this would go to that question of how the courts interpret the legislative mandates. And as Mr. Cook may be correct that the Guam adopted the model act of the drafters of this, it specifically goes from if the courts find a violation occurred, then there must be a repercussion to that. Attorney's fees is what these jurisdictions or legislative bodies determine if he is correct that there is no other jurisdiction. And I'm looking at the Illinois statute right now that there is no sanctions part of it. That was a legislative statement by the Guam legislature that sanctions shall accompany. And in a way, it actually says that if you find a SLAPP occurred, then you must find a sanction and attorney's fees as part of the deterrent effect so that other attorneys don't continue this. And the statutory scheme. What is the role of the judiciary relative to the legislative branch? And had the legislature intended that in mixed claims cases that no sanctions occur, then they would have put that in the statute, which does not exist. So that would be in response to that issue, Your Honor.
Thank you.
But thank you.
Please proceed.
Thank you, Your Honors. Your Honors, the Bernal case, the California Supreme Court case, they used the motion to strike as the discussion has gone to this point. And Guam specifically references in its statute under the definition 17-103 that a motion to dismiss that was brought is treated not only like a summary judgment, I believe as Enriquez had envisioned, but also specifically to strike. So Guam's statute is consistent with the Bernal treatment. And in relation to Justice Merriman's comment, Bernal dealt with civil issues. It was not a criminal setting. And that's why Mr. Vanderbilt's comment that this is the height of arguably what the legislature wanted to protect, which was criminal reporting, but it does not distinguish in our statute. Civil and criminal they do not diverge in the statutory scheme as put forth in the findings and the intent. Also, interestingly, the comment of equitable balance. There's the Jace Boston, which is the 2017 Massachusetts Supreme Court, Blanchard and Bernal, all talked about the equitable balance. It's not, as opposing counsel would say, the parceling out the protected claims is actually the best way of treating everyone fairly. Under AMT's analysis, the defendant, which would be Richard and counsel, and the government's interest would be severely damaged because the person would go on unmolested and they could take this to a jury. The problem also, Your Honors, is that our statutory scheme, which is consistent with all other anti-SLAPP statutes, they're intended to immediately stop the expenses to the defendant because litigation is expensive, as the courts know, and allowing this to continue through discovery about matters that were brought to the government's attention or not is damaging. And in this case, we have a Monamco who was sued by a corporation, which again is the classic SLAPP scenario. That was the Guam Greyhound situation. So I would respectfully submit that this is a classic SLAPP situation with the way that three corporations went after a Monamco who AMT did not even, and the two other corporations did not, they used self-help and did not go to the courts. And that should reflect upon the behavior, the bullying type behavior that's occurring. Also, the court pointed out this was not a sham, it was not appealed. I do not see this as an overruling of the Cho case. Your Honors, this is the next evolution. That's why I say there's a category of mixed claims cases which clearly talk about protected and unprotected activities. We're not making this up. This is actually part of the statutory, the case decisions by their highest courts in California. Also, Your Honors, Mr. Cook provides no broader picture type analysis, policy analysis here. He is hyper technically reading the statute in order to defeat a claim that the statute specifically was enacted to protect, which is claims to the government to protect the free flow of information so that a societal good can occur. Your Honors, I'm going to submit that if Mr. Vanderbilt can complete the time.
First off, Mr. Cook wants to ignore the preeminent, I think, purpose of the statute, which is under B1, to protect and encourage citizen participation in government to the maximum extent permitted by law. And in support of that concept, in paragraph 7, which you have relied on the Cho decision, it says, the threat of financial liability, litigation costs, destruction of one's business, loss of one's home, and other personal losses from groundless lawsuits. And I think you can read that narrowly when you're going to read it to the maximum extent permitted by law. You can read that to say that any cause of action which offends or contains allegations which offend, that part of the CPGA cannot proceed forward. And that allows for what was in Cho to go forward. As the Chief Justice pointed out, in Cho, there was a specific agreement not to make those kinds of reports. That doesn't exist in this case. In this case, it was a free and open opportunity for people to do exactly what the CPGA was intended to protect, which is to participate in government. There was no claim, no restriction against that participation. There's no agreement to prohibit that. So Cho is distinguishable in that respect on its facts. Mr. Cook points out that it was a trespass claim, but it's actually the harassment and tortious interference with business relations claims. And as I said earlier, if you look at page 650 and page 651 of the excerpts of record, you'll see that the judge made a factual finding that the complaints to the government were supported by evidence. That's not been appealed, not been disputed, and it has existed in all three of her decisions. Then when you get to B4, it says to establish a balanced, uniform, comprehensive process for speedy adjudication of SLAPs as a major contribution to lawsuit reform. It is clear, and when you go back to A8, it says, while courts have recognized and discouraged SLAPs, judicial protection of these important rights has not been uniform or comprehensive. I think the concept of comprehensive means even if it exists in some part, that part which is offensive has to be protected against. Litigants shouldn't have to expend their financial resources. They have to endure litigation over what is clearly designed to punish them for the exercise of their rights. And where Mr. Cook says that the letters don't support threats, all you need to do is look at page 318 of the excerpts of record and page 322, and it's absolutely clear that what is being referenced in those letters is the fact that certain business licenses that have been produced in discovery were turned over to law enforcement for them to consider whether or not there was illegal activity occurring. This is the heightened area of protected speech that clearly has to be protected. If people can be sued by lumping some portion of an action into a lawsuit that is clearly protected activity, then you're not meeting the requirements of being comprehensive. And so there is a way to narrow the holding of Cho based on the facts that existed in Cho and address what really is the more broader purpose, and to avoid the litigation costs. If these litigation costs are not avoided, then the whole purpose is, the central purposes of the statutory scheme go out the window. They're just lost because there'll be no, and the ability to bring a lawsuit afterwards for abuse of process, well, that doesn't meet the standard, because the standard under the statute is to do it at the beginning so that those costs are not incurred. So to suggest that the later remedy, which has existed and was known by the legislature when they made the statutory scheme, that somehow was sufficient, that's exactly the opposite of what the whole purpose of the statutory scheme is. It's to weed those things out early in the litigation to make sure that they don't burden a party and put a party at fear of loss because of the fact that they participated in their government. Thank you.
Thank you, Attorney Vanderbilt. Thank you, counsels. And Attorney Moylan, the next time you give Attorney Vanderbilt 5 minutes to argue, make sure you practice what 5 minutes means. But thank you, counsel, for all your arguments. This is a case, as you can see, that we are struggling with. And the court will take the matter under advisement